rise that extremism in the defense of liberty is no vice.
You won't settle for putting Susan B. Anthony on the new dollar.
I think you have no jurisdiction to make that concession, Mrs. Ginsburg.
Welcome to Beyond a Reasonable Docket, a Liberty Justice Center production where we talk about what's going on in the legal world and how it affects your civil rights. I'm Ryan Morrison, a senior attorney at the Liberty Justice Center, and with me is Reilly Stevens.
Good to be here.
And Brendan Philbin.
Hey, Ryan. Nice to be with you.
And they are also senior attorneys at the Liberty Justice Center. On the docket this month, we'll discuss two new bills that will allow individuals to sue federal officials that try to coerce tech companies into censoring your online speech. Then we'll discuss the Liberty Justice Center's most recent victory in our tariff litigation. And finally, we'll discuss the Supreme's recent decision about drug addicts owning guns in this month's trip to Motown. You probably remember that the Biden administration pressured social media companies to censor unfavorable posts and other speech that contradicted their COVID narrative. To help prevent this from happening again with artificial intelligence service providers, Congresswoman Harriet Hagman from Wyoming has introduced a bill to prevent AI censorship to the House. And Senators Ted Cruz and Ron Wyden have introduced a more expansive bill in the Senate called the Jawbone Act. So basically, guys, these are two new laws. Of course, they're just in the initial stages that are going to give citizens a cause of action against federal officials that reach out to social media companies to try to censor their online speech. As one of the press releases talks about, a lot of times these federal officials are political appointees. They end their service and then they go into the private sector. And so the case against the government is moot because you can't sue them to stop doing something when the official doing it is no longer in the government. What this will do will give them a cause of action for damages. So it'll hook that official even upon retirement. And just looking at the press releases here, first from the Congresswoman from Wyoming, her press release says, Harriet Hagman introduced the Preventing AI Censorship Act to give American citizens the right to sue federal employees who violate their First Amendment rights through the use of artificial intelligence. The act extends the framework of her previous First Amendment Accountability Act to future threat of AI-driven federal censorship. She mentions the Biden administration, how they colluded with social media companies to suppress constitutionally protected speech. And the current law left Americans with almost no recourse. As AI becomes the dominant platform for information, federal employees who pressure AI providers to filter content, distort outputs, or surveil users based on their views pose the same constitutional threat through a far more powerful tool, that being artificial intelligence. And looking at the Senate version of something like this, the Senate Commerce Committee Chairman Ted Cruz and Senator Ron Wyden today introduced the Justice Against Weaponized Bureaucratic Overreach to Networked Expression Act, or Jawbone Act, the legislation to hold the government accountable for censorship and violations of the First Amendment. A little description here. Jawboning occurs when the government pressures private companies to censor speech protected by the First Amendment. Americans face significant hurdles in improving these violations. Cases are dismissed when officials leave office or administrations change. Uncovering private communications between government officials and companies is difficult. Evidentiary and doctrinal hurdles preclude remedies, even in cases where the government clearly bullied companies into censoring speech. The Jawbone Act would create a cause of action against any government agency or employee that engages in jawboning, regardless of whether the censorship succeeds, and allow plaintiffs to seek monetary damages. It would also require agencies to submit to Congress certain communications with companies, ultimately strengthening oversight and accountability. Now, usually members of Congress in their press releases have greatly overstated the impact of their bill, or maybe understated it if they're trying to sneak something past. But this really seems like something that could be useful. The Senate, the description is correct. When people leave office, moots the case, because usually people are trying to pursue injunctive relief or equitable relief, not money. But when you put the money hook on there, people can owe you money for harming you, whether or not they're still in the position that they held when they harmed you. So this seems to be a positive thing. What do you guys think?
Yeah, well, I think at dinner, as I was, we were pulling this up Ryan, I noticed the ACLU has actually endorsed Ted Cruz's bill. So I
They have,
guess
yes.
I suppose we have many bedfellows involved in this. I think at this point, I think it's worth talking about where some of this is coming from. Obviously, right? The first, it's coming in both directions from both parties now, because of course, we have the well-publicized Biden administration efforts to influence social media companies around the pandemic, around some of the election fraud claims in 2020, et cetera, and so forth, and the way in which they were pressuring social media companies and pressuring other companies to limit speech that they thought was harmful or against the public interest. And more recently, you've had the current administration taking some very aggressive action, including against broadcasters, including against law firms. But the chair of the FCC has taken a very aggressive stance, and you'll notice that the Cruz bill specifically refers to broadcast networks and television and radio programming.
Mm-hmm.
And so I think what the Cruz bill obviously is trying to do here is address the events in both directions over the past 5, 6, 7 years in particular that have really damaged, I think, a lot of the faith people have in the government and the amount of influence it exerts over private companies.
Yeah, and I think that's fair. The Biden administration was more covert. The Trump administration has been more overt in their pressure to various media outlets and speech that they do not like. It never ceases to amaze me how elected officials get so touchy when people criticize them. It makes me wonder what they think they signed up for. But yeah, it seems to fire. The Foundation for Individual Rights and Expression, they've endorsed the bill. You mentioned the ACLU, Protect the First Amendment Foundation, the Knight First Amendment Institute at Columbia University, Abundance Institute, the Center for Democracy and Technology, the Institute for Free Speech, Public Knowledge, Americans for Tax Reform, for what that's worth, Advancing American Freedom, Independent Women's Voice, and Internet Accountability Project have all endorsed the bill. I don't know if they called us or not, but we haven't really dived into the text of the bill, but we've got some of our usual friends on the record saying this is pretty good. What do you think, Brendan?
Yeah, I don't even need to hear anything more. In our business, whenever there's a new cause of action against the government, it's a great time to celebrate, because that can get us into court easier and allow us to hold these government actors responsible. So I think that's telling that so many diverse groups that make their living off of suing the government are celebrating this. So I'm for one excited, but we can dive into the details if you want.
Yeah, well, I have the text in front of me. It's long. We're not going to read the whole thing, but the key point, the prohibition that is the cause of action here, is that it'll be unlawful for agency employee in the United States, et cetera, to coerce a broadcaster, a provider of an interactive computer service, a provider of an artificial intelligence system, incentivizing the broadcaster to take a content action. And the content action is basically like forms of censorship.
Sure, and that incentivizing could be carrot, as it seems to imply, or more likely stick, I'm sure.
Yeah, and then the question, I think the $64,000 question is, what is coerce? So if we go look at what coerce means, right? Coerce means to take a harmful, hostile, or unfavorable action, to imply the possibility of taking such action, or threaten to take such action.
Yeah.
So
the game will probably be implied, if I had to guess. Yeah.
I wonder if regulatory action is harmful on its face. That would be weird, because a lot of this is threatening to take some audit or something like that in a lot of these cases. So I wonder if that would be harmful on its face. It's an interesting question.
It would be a lot of fun to be able to sue the government for just doing its job. I mean, that would be kind of fun. But then again, they always say they're just doing their job whenever we sue them.
Right, and that's the trick, though, Ryan. Right, is that occasionally these things might really be a real proper, nice little company there. Be ashamed if anything happened to it kind of situation. Often as not, what you have are real, legitimate regulatory questions, real, policy issues that the government is dealing with that really affect, this or that company. And there's government discretion as to whether or not to approve this merger, or whether or not to approve this license, or whether or not, the contractor should get this big contract from the government, right? And those are situations where there can be a lot of money at stake. There can be even the future of a company at stake. But it's not, the government is going to have to make some kind of decision, right? And so how do you get into how do you, and there are instances where the government goes to a company and says, okay, we're going to give you this permit, but you have to fix X, Y, and Z, you're dumping too much stuff into the river or something, right? You put conditions on the permit, that kind of thing. And so how do you actually draw the line between, how do you demonstrate the intent and the malfeasance when so many of these things fall under ostensibly legitimate authority?
Sure. That pollution example, I think that'd be difficult. But perhaps since this is speech context, get rid of that speech or get rid of that reporter or do something about that one show. Maybe that's a little bit more obvious. I don't know.
Yeah.
What? Sorry, right? What do
ahead.
the damages look like here?
I mean,
what's
I
the
don't
theory
know.
there?
What's your constitutional rights worth? Priceless, I guess. So I guess.
Yeah, I mean, that's what we always run into that in First Amendment context where we sue for damages, and often it's tough to come up with a number beyond $1.
So
see how that.
So
turns out.
if you go to page 10 of the bill text, the private right of action says civil action for compensatory damages. So that's normal damages that just where you would put in evidence saying how much it harmed me that I lost my job or I was deplatformed or whatever the case may be. And I guess one problem we could talk about is says that any individual person who loses their Twitter account, how much damage is that really if they're not a celebrity who has a big Twitter following? And then it gives you attorney's fees, so you can get fee shifting. So the lawyers will get paid.
Yeah, that's the part we care about the most. Now, I'm kidding, everybody out there. I'm kidding. We do this for the love of the game. Anyway, well, it definitely is a new world if these things get passed, and of course, as we all know, the language will get tweaked, even if it gets enacted. I don't know. And of course, the executive branch, whether it's whoever's in office, may have some objections to this because they don't want to expose their people to liabilities that may get vetoed, regardless of who's in office. But then, so we may have to get a veto-proof majority to get something like this passed. But anyway, it's a great first step, and we'll see what happens. As you recall, the Liberty Justice Center stopped the president's initial tariff efforts at the Supreme Court earlier this year. And just like any good comic book villain, the tariffinator vowed to return. And since we all know President Trump is a man of his word, he imposed tariffs again, this time using Section 122 of the 1974 Trade Act. So, Reilly, did he get away with it this time?
Well, it remains to be seen, Ryan, because the case is still ongoing. But so far, the Court of International Trade has said that he can't do this, is the punchline. What this case comes down to is so we have two clients that the Liberty Justice Center is representing, right? So Burlap and Barrel, the first client is a spice company. They make, garlic powder and barbecue and they have a good barbecue rub that I tried that was quite good. I'm going to try the curry powder here, I think, later this week. And we also represent a company called Basic Fun Inc., which is a toy company. They actually have the rights to a whole bunch of very famous legacy toy brands that you and I will remember from our childhood. Tonka trucks, Care Bears,
Sure.
Light Bright, Lincoln Logs. I was joking with Jay that if he can just get Power Rangers, he'll have the monopoly of my entire childhood. But in any case, these clients came together to challenge the new tariffs put in our Section 122. So back in February, we got the decision from the Supreme Court that said that we were right that the IEEPA tariffs were illegal and outside the president's statutory authority. That same day, the president issued these replacement tariffs under Section 122 of the Trade Act of 1974, which it's essentially a blanket 10% on the world with a whole really long list of exceptions, but in first budget is a worldwide 10% tariff. Section 122 lets you put in tariffs of up to 15% for up to 150 days to cure balance of payments deficits. This is the important phrase, Ryan, we're going to have to come back to and explain what it means. That when there's a balance of payment deficit, Section 122 says the president can impose tariffs on the entire world to fix that economic crisis, okay?
Sounds like a big deal. Anyway, go ahead.
Yeah. And so the question is, what is that? So we have to go all the way back to 1971. President Nixon, faced with a balance of payments crisis, had to close the gold window, okay? So prior to that, we had been on a gold-based monetary system where the United States would redeem dollars for gold at a fixed rate, a fixed number of dollars for gold, and then there were fixed exchange rates with all the other currencies around the world, kind of thing. and so the problem with that is if the market value of gold gets out of whack with the official government price of gold, redeeming the gold becomes very appealing, and all of a sudden people do it a lot more. And what happened in the 1960s was all of a sudden people were redeeming gold faster than the government could replenish their supplies, and we ended up with a situation where we were not going to have gold to cover the dollars anymore.
So,
That is a
okay.
balance of a balance of payments deficit. That is the amount of gold you have to cover your gold-backed currency is running out.
Okay.
Okay. So and so the trick with that is after 1971 and finalized in 1976, we went off the gold standard completely and we went to a floating exchange rate system. Now, if you're going to Europe or if you're going to Japan or something, you get to the airport, you see all the little you see the currency exchanges on the wall where you can change your thing at different rates. Those rates fluctuate. And so you never get that balance problem in practice, the economist will explain, because the currency exchange rates float and that will adjust the market prices to wherever they need to be.
Yeah, it seems like it's almost like instantaneous. And so
Yes.
what you're really shopping for is whatever the lowest transaction fee is for your currency exchange.
Right. But what the president wants to do is he wants to say that he's claiming a balance of payments deficit because there is a trade deficit. And the balance of trade is actually kind of a subset calculation of the balance of payments of the entire country.
But they're not the same, though, right?
No, one is a subset of the other, essentially.
Okay.
And the trick with the trade deficit is it is balanced out by other numbers that make up the balance of payments deficit, including something called the current account. And the sort of layman's way of explaining this is when you have a big trade deficit, what that ends up causing is more dollars come back in investment. You end up with an investment surplus because these people abroad have dollars and they have to spend them somewhere. They come back and they invest them into the American stock market, into American real estate, into building American factories, these kinds of things. And so what the economists will say, and we have 22 economists on an amicus brief in this case, including a couple of Nobel Prize winners, explaining this, that essentially the administration's position is playing games with the meaning of words such that they want to broaden out the balance of payment deficit to include any kind of trade deficit, which in principle would mean actually that we should have had Section 122 tariffs for about the past 50 years because we've had a consistent trade deficit since about the mid-70s, actually.
Wow. And when we say trade deficit, that is we're buying more goods than other people are buying from us, but we do more services to other people than we get from them.
Yeah. Specifically, the trade deficit in goods, right? As in, goods, as in physical goods, as opposed to services like financial advice or financial services, those kinds of things. Sure. The idea is that we tend to import things manufactured in China more than China imports things that are manufactured here in America. This has been obviously a big theme of the current administration, the current president's. He feels very strongly that is an issue that we need to correct, obviously. And so that has been where all of these tariff policies are coming from. At bottom is this idea that the trade deficit is an inherent problem. The trick is that is not really the consensus among economists. They tend to view it as not a problem at all in principle, but that has been the view of this administration.
Be that as it may, you still have to comply with the statute in order to impose this tariff, and it doesn't seem like there's a balance of payment problem to be fixed.
Correct. And so we filed this lawsuit saying there is no current balance of payments deficit. The United States is not currently undergoing. I mean, I think, the way that numbers work in these calculations, Ryan, I think there's like a 0.004% balance of payments deficit currently because the spreadsheet doesn't always add up.
Sure.
But there's not a significant one, and the statute actually, by its terms, requires it to be significant. And so we filed this case with the Court of International Trade, and the question for the Court of International Trade was, does what the president is doing here fit within the language that Congress wrote? And the language that Congress wrote has this term. And so what we had to do was we had to go back through about 6 or 7 years of economic history, a whole bunch of legislative history, a whole bunch of economic literature, and demonstrate as clear as we could that, this term is a term of art that means something. And that, we can show that the Congress in the 70s would have meant what the economists mean by it, right? And we were lucky and I'm glad to say the Court of International Trade agreed with us. And 2-1 found that, in fact, yes, that there was no balance of payments deficit within the meaning of the statute, and that therefore these tariffs, like the IEEPA tariffs, were, in fact, what a lawyer would call ultra vires, just illegal.
Yeah, beyond the government's power. They're just doing stuff that they don't have any authority to do. Yeah, so the vote was like 2-1 there. Is that right?
Correct. We had a 3-judge panel in the Court of International Trade, and so it was a 2-1 vote that we won by. There was one judge who dissented, and the dissent, and picking up on some of the arguments from the administration, relies on, number one, the fact that there's a lot of case law saying that the president gets discretion. These are obviously decisions that are meant to be a decision that the executive branch makes, right? It's not entirely true in this case because this statute is actually mandatory. It says the president is supposed to take action if there's a balance of payments problem. So if, by the president's definition, the trade deficit counts, we should have actually had Section 122 by its terms. It was required to be in place before this.
Oh, wow.
But it wasn't. And it is quite obvious if you look at the public statements from the administration and the public defenses that have been made of this, and just the way that this all went. This is not really about the balance of payments. This was a statute that gave them a reason to recreate some of the IEPA regime that had been struck down.
Sure, I'm sure it was pretext. It was like grasping for some kind of tool, and it was the first one they could pick up and use. I mean, anybody's paying attention can tell that. But still, if you have the legal authority to do it, you still have the legal authority to do it. And so far, the Court of International Trade says no. So what happens next, Reilly?
Right. Well, I'll just say, and fair enough to them, Congress is not full of economists, and Congress can mean whatever it wants to mean, right? It could define a term to mean whatever it wants to define it as, right? Yeah. So, it was incumbent on us to make the demonstration that this term actually does have the kind of meaning that the court can read into it. Because, in principle, when you're doing textual analysis, it doesn't matter what the economists think. It matters what Congress was thinking in 1974, right?
Mm-hmm.
And how that law was understood rather than what an economist wishes it would be understood as. And
Sure.
So that's the government's best argument. We, I think, have the better of the argument that in this case, words mean what they've always meant, and there's no real other authority that it ever meant anything else.
Okay. So we've won there again. And we're building up our frequent flyer miles to the Court of International Trade. So I guess it's off to the Federal Circuit now for the appeal.
Correct. It is currently we won, and then the government appealed, and so the case is currently pending Burlap and Barrel, and also there's the state of Oregon's case, which is also a number of states. State of Washington was actually the only one that survived in the district court. But we are all together now in the Federal Circuit, and that court is now going to have this case briefed in the next few months.
Sure. And do we anticipate this moving as quickly as the previous tariff litigation?
Probably not, because in the previous tariff litigation, the government itself filed a motion to expedite the case because they wanted to get to the Supreme Court quickly. In that, they have not done that in this case. They seem more willing to take their time with it, and so therefore it's proceeding a bit more along normal order here, where they'll be briefing for the next few months instead of over a month or two. And so I expect briefing will be, by the end of the summer, into the fall, will probably be when we finish briefing.
Okay. Well, then, it looks like this will not be on the Supreme Court's docket by October. Maybe we can get it there before the end of next term, but at this rate, I don't know. We may have to wait for 2 Octobers before we get there.
Well, and these tariffs only last 150 days, but they actually expire here in July. But the money will still be, the question of the return of the money will still be out there, and we will be litigating it as long as it takes, just as we're actually still litigating the IEPA case to make sure that as many people get their money back from that as we can as well.
All right. Well, it's a never-ending battle against the Trump administration's tariff initiatives, to be sure, and we'll see it through to the end. You may know that when you buy a firearm, you must declare on a federal form that you do not use illegal drugs. But when Ali Hemani was busted for owning a gun while, quote, being an unlawful user of a controlled substance, Mr. Hemani objected and argued that not all potheads are created equal. Basically, Hemani's position was that the Second Amendment is an individual, not a collective right. Accordingly, the law cannot treat all drug addicts the same because smack affects junkies differently, and there is a difference between crackheads that smoke every once in a while versus those that smoke daily. The Supreme Court decided to take his case. So, Brendan, what happened when Skid Row went to Motown?
All right. Well, look, this is not about drug addicts, and we're going to get into that in a little bit. This is just about drug users, because that is an important difference. But before we start, I saw, I'm not a big internet guy, but I did see a meme of the Moana, The Rock singing You're Welcome, and it's libertarians singing You're Welcome, because we are dealing with drugs and guns, and this is the first, I think, unanimous 9-0 decision upholding gun rights in Supreme Court in a long time, if
I think
ever.
you're right,
So,
yeah.
yeah, so that's nice. So, us with the libertarian bent can take a victory lap here. So this is about Ali Hemani, who is a dual citizen, U.S. Pakistani, but born and raised in Dallas, stable job. And he was the target of a terror investigation. So a warrant was served on his house. So they charged him 18 U.S.C. 922 G3, which that prohibits the possession of guns for unlawful users of addictive or controlled substances. So during the warrant, Mr. Hemani was pretty good. He handed over his firearm, and he actually pointed out where his marijuana was. And he said that he uses it a few times a week, and that was really it. He also pointed out that the cocaine that was in his mom's, it was in his mom's closet, and she said
he threw mom under the bus. Oh, wow.
yeah, and he said his mom was hiding it from him.
From him?
And so he was, so he wasn't using it, but that's irrelevant, because he wasn't charged with any drug trafficking crimes, anything. He was just charged with this 18 U.S.C. 922 because he said he used marijuana a couple times a week and he had a legal firearm. So he challenges this under the Second Amendment. And we know since Bruin, the Second Amendment, the government has to find basically a historical analog of the law they are enforcing today back around the time of the founding. So
basically, if George Washington could have gone to jail for smoking crack and having his musket, then this guy can too.
Yeah, so it doesn't have to be exactly on point, but it does have to be a historical analog. So the government in court, it's kind of like choose your fighter, right? What historical analog is the government going to pick? And they chose as a historical analog to 922 G3 habitual drunkard laws.
Okay.
And they did not choose wisely.
So the knight in Indiana Jones, The Last Crusade, made an appearance.
Yeah.
Chose
and they
poorly.
The DOJ attorneys from the line prosecutor all the way up just grew that beer and just turned into a skeleton, because they really jacked this up. But it's really fun reading about what was habitual drunkards, and I think the court had a lot of fun with this, and it's we're recording this coming up on the nation's 250th anniversary, so we can go back to the nation's first birthday and talk about what were habitual drunkards, right?
Sure. As I recall from
what are habitual drunkards, Brennan?
Yeah, well, as I recall from the oral arguments, they were talking about our founders being real party animals. Anyway, go ahead.
Yeah. All that made it into the opinion. So the court said, look, habitual drunkard laws that's basically vagrancy laws, civil commitment laws, and surety laws. And to test those, the government said Mr. Hemani is like these because he's a regular user of intoxicants. These laws are prohibiting unusually dangerous or violent behavior, and they basically detain you in a place where there are no firearms, so they disarm you. So the regular user one, to Reilly's question, going back to the late 1700s in Pennsylvania, it is you have to be drunk half the time. That is, they pulled a case law from the
Okay,
Commonwealth of Pennsylvania.
okay. So if I sleep 8 hours a day, if it's the 16 hours awake, do I have to be drunk 8 hours of the 16, or is it like 12 of the 24, or what's the denominator?
They did not get into the objectives. They chose to really use math to discuss George Washington's retirement party, which we'll touch on in a second here. But basically, the court summarizes habitual drunkard laws as you drink so much you cannot handle your own affairs. So the court says, look, this is using intoxicating substances to the point where you can't handle your own affairs. And if we were just criminalizing regular use, then the founding fathers would have been in trouble. They quote Benjamin Rush, who's a great Pennsylvanian, was probably the first combat medic of our nation. He said he would pass through cannon fire to get to a keg of rum in a corner, right? George Washington's retirement party at City Tavern, there were 55 guests. They consumed 154 bottles of alcohol, plus 7 bowls of what we knew in college as jungle juice. The Supreme Court quoted it as punch. And then they go through to talk about just the daily meals of some of the founding fathers. John Adams drank a tankard of cider with every breakfast.
How much is a tankard?
I have no idea. It sounds like a lot, though.
It does sound like a lot, but anyway, go ahead.
Yeah. And then James Madison drank a pint of whiskey every night too. So these are regular drinkers. So clearly the analog of habitual drunkards does not fly here, because everyone would be in trouble. And the court also quotes that the government kind of, through its policies dating back to 2013, not prosecuting marijuana offenses. And now there's more marijuana users in the United States than alcohol users. So if you followed the government's conclusion, we would kind of all be in trouble here. So look, the government loses because these habitual drunkard laws don't criminalize regular use of alcohol or other intoxicants, but the Supreme Court is having too much fun, so they're going to run up the score on the government a little bit. And so they're going to get into vagrancy laws now and talk about the government said, hey, these laws target unusually dangerous or violent behavior. And the court said, no, vagrancy laws are because people did not meet the societal expectation of work. So it's pretty interesting. Like, if you were not carrying your weight in society and not doing work, they would there were processes to put you in like kind of a work camp kind of scenario.
Oh, wow.
And put you to work. Yeah, pretty wild. So the government loses there too, because their theory is that this law protects the community from violent behavior of drug users, and it's just not the case. And finally, the how of this, there was always, in all of these, there were pre-deprivation processes. And here, there is none. You're charged with the crime. You could do 15 years in jail, and you're disarmed instantly when you're arrested. So there was no pre-deprivation due process available here, and there was under these vagrancy laws. So pretty interesting case, a nice history. The founding fathers were, real party animals. I hope at the 250th coming up, we all adopt that spirit and able to let loose a little bit. But great victory for Second Amendment and logic here.
Yeah, fair enough. Let's see. I don't know. Put too fine a point on it. You mentioned there's like a difference between the user and the addict.
Yeah. So the Hemani Hemani, he was not an addict. He was just a user. And the court goes through and says, hey, if you take a weed gummy once a night or once a week to help you sleep, you could be disarmed under the government's theory. So the end of the opinion does narrow it a little bit, and they say, hey, if you could prove that the individual is violent and his addiction to controlled substances makes him a violent individual, then that's certainly fine, because you're protecting the community. But just a facial claim that you're a drug user in any amount of any substance, and you therefore cannot use you cannot possess a firearm is a bridge too far.
Was violence the only character trait they were concerned about? What about like carelessness or something like that? I mean, I'm thinking like how somebody operates a motor vehicle while intoxicated. They could hurt somebody. If you're handling a gun while you're high, could have something bad happen too.
You could, but the law is just possession. So you could have the firearm cleared in a safe position, locked in your house, and you are still running afoul of the law if you have a weed gummy to go to sleep. So it doesn't matter the handling or Yosemite Sam shooting it in the air. Yeah. That's not really at play here. It's just possessing it in a safe way is enough to criminalize it under the government's theory, which fortunately lost resoundingly.
There's actually a whole line of like Warren Court cases, and and they're not citing them here, I think, because they don't like the Warren Court cases. But
surprise,
that says Robinson versus California, which said you couldn't actually criminalize being a heroin addict. Not as opposed to possession of heroin or public intoxication. There's another case called Powell versus Texas that says you can publish public intoxication. But actually, Robinson, which Gorsuch doesn't cite as far as I can tell here, it would actually, in California, they would say that it was a crime to be a person who was addicted to heroin, basically. And the Supreme Court back in the Warren Court era said you couldn't do that. That was essentially criminalizing a status that you couldn't help. Right, if you're an addict,
right?
But this came up in a couple years ago. There was a case about homeless in camping and whether or not there was any place for the homeless people to go. And the Supreme Court, and of course Justice Thomas said that he thinks that Robinson's wrong for all the reasons he usually defends from such things. But I take it this didn't really come up. The fact that there's a whole Supreme Court line of cases saying you can't punish status.
No, they for whatever reason I think they had enough just slapping down the government's choice of habitual drunkard laws here, so they didn't need to get into that.
And I'm glad that Reilly mentioned Justice Thomas. This is kind of going a different direction a little bit, but I didn't read, but I heard about his concurring opinion, and it raised an extremely interesting issue that hopefully we'll see raised again. Why don't you talk about that for a second?
Sure. So this law is passed under the Commerce Clause, and it's firearms passing through interstate commerce, and that's how the federal government can regulate that. And he said that basically the Commerce Clause, and he's been consistent pretty much throughout, that the Commerce Clause is only for regulating businesses, not possession of firearms or a whole other slew of things that the federal government uses the Commerce Clause for. So yeah, it's nice. It'd be nice to take a couple chunks out of the Commerce Clause before he retires. We're recording this on his birthday, I think, Justice Thomas, right? Yesterday. Yeah.
So that's really cool. You're right. He's very consistent on that. He doesn't think just because that your gun arrived at the store on a truck gives the government the power, at least the federal government the power to regulate the sale and possession of that weapon. And if he ever gets his way and the Commerce Clause is taken down a couple of notches, it will be revolutionary, and there'll be weeping of gnashing of teeth in the bureaucracy in Washington, D.C.
And we'll be celebrating like George Washington when he retired.
Like George Washington's retirement all over again.
Yeah.
Exactly.
Yep.
But at the end of the day here, it's great to see that the Second Amendment is starting to get some well, I guess I shouldn't say getting some traction. It has its traction. It's on both feet standing and getting the respect it deserves. Thanks a lot, Brendan.
Thanks, Ryan.
They are Reilly Stevens and Brendan Philbin. I'm Ryan Morrison. We're all with the Liberty Justice Center. Thank you for being with us today. Please subscribe to Beyond a Reasonable Docket podcast and tell your friends to subscribe as well. We appreciate your 5-star ratings and your kind reviews. They are a really big help to us. Follow the Liberty Justice Center on all social media platforms and come visit our home on the web, libertyjusticecenter.org, where you can sign up for the Beyond a Reasonable Docket Substack too. We hope you had a great time with us today, and please join us again for the next Beyond a Reasonable Docket.
Court stands adjourned.